When we go to a bar, we have certain expectations. We expect that a bartender will not encourage a recovering alcoholic to drink. We also expect that a bartender will not feed drinks to someone who is visibly intoxicated. And of course, we expect that a bartender will not leave a loaded weapon next to a now relapsing alcoholic. But that is exactly why we are here today. The defendant, Michael Scott, police chief at Mifflinville. He betrayed our expectations. He encouraged a recovering alcoholic to drink, and he kept feeding her drinks past the point of visible intoxication. And finally, he left her alone with a loaded gun. Good afternoon. My name is Victoria Rosling, and along with my partner, Thomas Wood, we represent Pam Halpert, who is here today to hold the defendant responsible for the actions that led up to the death of her husband, Jim Halpert. On the weekend of September 24th, at 7:32 p.m., Ms. Schrute is standing over the body of Jim Halpert. Her eyes are red and watery. Her breath smells of liquor as she stands in horror of what she has done. Let me introduce you to Ms. Schrute. Ms. Schrute works as a counselor at Dunder Rehabilitation Center. She helps people who are on the path to recovery from drug and alcohol addictions. Why? Because she herself is a recovering alcoholic, and she wants to give back to a community who helped regain her sobriety. But you will hear that on the weekend of September 23rd, Ms. Schrute broke. As she sat on a park bench, she looked over and saw Jim Halpert walking away with someone she had deep affections for. The defendant was there, and he said, "You can kiss that one goodbye." Jim takes what Jim wants. Then he poured her a drink. Initially, Ms. Schrute refused, but the defendant kept egging her on. And then he said, "Come and drink with me. We will drown our sorrows." And at that point, Ms. Schrute broke. She relapsed. Shot after shot after shot, the defendant poured and Ms. Schrute drank. And you will hear today that had it not been for the actions of the defendant, Jim Halpert would still be with us. Pam Halpert is here to hold the defendant accountable for his actions. She is suing him for negligence. Now this means that he acted unreasonably, which led and caused the death of her husband. And we're going to prove this in two different ways. The first is that it was the defendant who fed Ms. Schrute alcohol past the point of visible intoxication. And second, that it was the defendant who mixed guns and alcohol together. On that first issue, at the end of this trial, the judge is going to instruct you on an act, the Dunder Dram Shop Act. And in this act, it deems it illegal for someone to serve alcohol to someone who is visibly intoxicated. Now, it presumes that someone is visibly intoxicated if their blood alcohol content was 0.08%. You will hear today that Ms. Schrute's blood alcohol content at the time of the shooting was 3 times that legal limit. So anyone who served Ms. Schrute a drink would know that she is visibly intoxicated. Today you will hear from Ms. Schrute. And she will tell you that on the weekend of September 23rd, she came to a party at the lodge. And on that first night of Friday, the September 23rd, it was the defendant who offered to go buy more alcohol. Now on to my second point. That it was the defendant who mixed alcohol and guns together. The next witness you will hear from is Ms. Martin. And she will tell you that the defendant came back on the morning of September 24th with alcohol and placed it on the same table as the guns. And then Ms. Schrute will also tell you that on this day, for every shot that she took, it was the defendant who poured it. And then it will come to the evening of September 24th, where a dangerous game of quick draw ensued. Ms. Schrute would pull out her gun and fire at Jim Halpert. And you will hear it was the defendant who encouraged this dangerous game of quick draw. He called Ms. Schrute a quick draw wizard. And you will hear that moments before the shooting and right after he made that statement, he turned around and walked away. Ladies and gentlemen, we have certain expectations for police chiefs. We expect that a police chief will not encourage a recovering alcoholic to drink. We expect that a police chief will not continuously feed a recovering alcoholic drinks past the point of visible intoxication. And of course, we expect that a police chief would not leave a recovering alcoholic who is now relapsing alone with a loaded gun. We ask that you hold the defendant accountable for his actions that led up to Jim Halpert's death. We ask that you hold him liable. Thank you.
Thank you, counsel.
Honor, at this time, the plaintiff rests its case in chief.
Thank you.
Your Honor, assuming we're outside the presence of the jury, the defense would like to move for justice as a matter of law under Rule 50. Under the facts most favorable to the plaintiff, they have not shown an actual degree of the plaintiff or the defendant acting unreasonably in this manner, or that the person was visibly intoxicated at the time that any alcohol was served, and therefore, because there's no evidence that the plaintiff was that the witness, Dwight Schrute, was visibly intoxicated at the time any alcohol was served, there was no negligence.
Any response?
Yes, Your Honor. Under Stipulation 15, both parties have already agreed that, quote, no further motions to dismiss will be entertained because motions to dismiss have already been filed and denied, but I'm happy to respond to counsel's motion if you would like me to do so.
Please do so.
Okay. Your Honor, under Rule 50 of the FRCP, accepting all reasonable inferences on behalf of the non-moving party, in this case the plaintiff, we have presented sufficient evidence for a rational trier of fact to find the defendant is negligent. We asserted two theories of negligence. One, negligence per se, and second, premises liability. So on that first, negligence per se, both parties stipulate that it is a violation of the Dram Shop Act to serve alcohol to someone who is visibly intoxicated. Visible intoxication is assumed where the blood alcohol content is at 0.08%. Dwight Schrute testified the defendant served her hard liquor until she was drunk. In evidence is a blood test result, which shows that Ms. Schrute's blood alcohol content was 0.24% at the time of the shooting. Now this is 3 times the 0.8 minimum standard. Thus, a rational trier of fact could conclude that the defendant was negligent per se by violating the Dram Shop Act. Now on to the second theory of negligence, premises liability. A property owner owes a duty to keep their property safe to invitees. We heard testimony for both Ms. Schrute and Ms. Martin that the defendant placed loaded firearms on a picnic table right next to alcohol and allowed guests to play a dangerous game of quick draw on the defendant's property, which resulted in Jim Halpern's death. Thus, a rational trier of fact could conclude that this created a danger to an invitee, which is a negligent act. Therefore, counsel's motion should be denied.
Thank you. At this time,